Whenever we start talking about privacy, I love to start with this quote from Scott McNealy, who was the former chief executive of Sun Microsystems, and he says, "You have zero privacy anyway, so get over it." And I think privacy certainly has different meanings to different people in our online environment. But let's take a look at the foundations of privacy and kind of how it's been shaped from a legal perspective. I hate to break the news to you, but privacy is not a constitutional guarantee. So we have a couple amendments that will provide us with some idea of privacy, but really it takes some interpretation. In this case, we have the Fourth Amendment, which says that people have the right to be secure in their homes against unreasonable search and seizure, and that has been deemed to protect us. And then this Third Amendment, that soldiers can't be in your home unless it's wartime, is another one where we have looked at that as a privacy provision. I have to ask, though, what does privacy mean now? We put so many things online, pictures, our activities, our location, our histories, our birthdays, all of these things that would be considered to be private information is now out there. The idea of cookies, I recently searched for a hockey helmet for my son, and I'm intrigued how every time I'm on Facebook, it offers to sell me a hockey helmet. I only need one, though. So, the idea of the fact that I can my location is trackable through my smartphone, that I put my location on Twitter. People are checking in using things like Foursquare. What about, your online activities in the workplace, the online banking that you do? What about information revealed by minors? All of this really comes into question what we're going to do about privacy. So the sources of our present privacy protection actually gets incorporated into that word of liberty. It's been determined by the court that liberty includes personal privacy. We have a great deal of protection within the framework of the bedroom, so things about contraception and abortion, things like that, have all been fitted under this privacy realm. But we have not a great deal of protection against the media or the government or any other snooping that might go on. Now, privacy law begins in the 1890s in the Harvard Law Review when Samuel Warren and Louis Brandeis said that human dignity requires protecting individual rights. And the area of privacy law was really fleshed out by William Prosser in 1960, where he identified these four privacy categories that you may have heard of. One, appropriation. That's the idea of taking someone's name or likeness for trade purposes to make money off of it. The idea of intrusion upon seclusion, so actually intruding upon someone's privacy. The public disclosure of private facts, so things that we would like to keep private that are revealed without our permission. And then false light, which we'll certainly dig a little deeper into, but where you're basically revealed to be a person that you're not. Now, appropriation means two different things really to two different types of people. The first type of person would be someone like you and me, who we're just living our life, and someone takes our name or our picture or our voice or something like that, and they use it in order to make money for themselves. That is appropriating our image. The other category would be people who are famous, and they actually have a right of publicity. So they have a right to make money off their own image, and if someone were to come along and by taking their name or picture or voice, etc., and make money off themselves and it causes economic harm, that's also a violation under this. Now, the case that I want to talk to you about here is this one, where we have a gentleman who's turns out that his insurance company or an insurance company had used a before and after picture of him to illustrate someone who bought life insurance. So he ends up suing them, and the court found that this violated both the First and the Fourth Amendment for him, that he had the right not to be engaged or to be identified as being part of this product. So what we really kind of weigh is this privacy versus publicity. So private people have a right of privacy. This protects us from the emotional damage that can be caused when our name or likeness is used for commercial or trade purposes. And then, as we mentioned, this right of publicity. So this is if I'm going to I'm a famous person, I have the ability to have my likeness used and be compensated for that. So only with commercial value is someone able to claim the right of publicity. There are actually exemptions to this and protections for us. One, the idea of news or information. So if we, for example, when a celebrity is in a car accident and there's a photo that's run in the paper, they can't claim a right of publicity, that they need to be compensated in some way. Also consent. So you can actually get consent from people. And so a lot of times what we'll have are model releases or people you may have signed in the past some sort of consent that says, yes, you can use my image to promote your activity, or because I'm part of it. And then there's something called incidental use, the idea that there's a fleeting or brief use permitted. So if you're a face in the crowd of you're at a festival and the next year they use a picture to promote their festival, you happen to be in that group, you can't turn around and claim that you now should be compensated for that. We also have something called the Booth Rule. And that comes into play here with a woman named Shirley Booth versus Curtis Publishing, which published a variety of magazines, Saturday Evening Post for one, in this case Holiday Magazine. So they actually had done an article on her. She was quite a famous actress at the time. She was they had a photo of her vacationing in Jamaica. So she consents to the article, but then when they turn around and use the same photo to promote their magazine, she sues. And what the court says is that the advertising was doing nothing more than an incidental use as it related to promoting the magazine, and she'd already given permission to use the photo in the first place. Now, consent doesn't work all the time, and so just because you've given consent once doesn't mean that you can give it again. So, think about someone who maybe was in a band, if they were in a small band when they were in high school, and they give consent for their image to be used for something, and then they suddenly become quite famous. So if it was, 21 Pilots or Rascal Flatts or someone like that locally, and then they become famous, we can't use their image in quite the same way. Also, people, not everyone can give consent, so minors cannot give consent for themselves. That requires parental consent. People who are mentally ill also are protected and cannot give consent. And then people who are incarcerated also have protections. And that idea of consent can also be lost if you do something to substantially change the image. So if you take someone's face and put it on someone else's body, that level of consent no longer is applicable.